Hey, everybody, welcome back. I'm Nick Morgan, co-founder of ICANN Investor Choice Advocates Network, and welcome to another episode of SEC Roundup. We are excited today to welcome our guest, Andrew Terezny, who folks will know was the former director of enforcement, currently a partner at Debevoise. Andrew, thank you for joining us.
Thanks for having me. It's great.
And as always, joined by my co-host and co-founder, Tom Zucchero. Tom, thank you for joining.
My pleasure.
Let's just start with you, Tom. So we're here. This is actually part two. Last week, we spoke to one of the affected accountants, Ira Wiener, whose action was dismissed by the SEC. But maybe just rewind a little bit and give us some context. What happened recently, and why is this? Why are we here?
Yeah, thank you, Nick. So the recent event is the commission's decision to dismiss a series of 102E administrative proceedings against CPA, Certified Public Accountants. The background here is that the commission has the authority under Rule 102E to suspend accountants from appearing before the commission, which essentially means the accountant cannot do any work for a publicly traded company. The standard has the accountant engaged in improper professional conduct, which is defined to be either one act of highly negligent conduct or repeated acts of negligent conduct. These cases traditionally were handled administratively. The Division of Enforcement would file an administrative complaint, be assigned to an ALJ, and litigated completely in the administrative context. As our listeners know, in June, the Supreme Court decided the Jalkesi case, where they found administrative proceedings to be unconstitutional in the context of that case. There, the commission was seeking a civil money penalty, which the Supreme Court said required a trial by jury and couldn't be done administratively. Not clear that decision would have applied directly to 102E proceedings, although the argument has been made, and some courts have said that a 102E penalty is a penalty, therefore subject to the constitutional right to trial by jury. But before this issue was litigated, the commission decided sua sponte, or at least the Division of Enforcement decided, to move to dismiss 8 pending contested 102E administrative proceedings, one of which we were handling, and one of which Andrew was handling, and signaling, I think, at least for now, the commission doesn't have the appetite to try those cases administratively. And many thanks go to Andrew, who was litigating this case in federal court and nipping at the commission's heels, which probably led the commission to say, we don't want to fight Andrew Terezny, we'll just walk away from these cases. So with that, I hand it over to our distinguished colleague, Ms.
Yeah, let me just back up, because Tom, you said a couple of things like we think this is why the commission is dismissing these. Of course, they haven't said. These are one-sentence motions from the enforcement division, and in most of the matters, one-sentence dismissals from the commission.
Yeah.
But as you say, Andrew, you may have more insight on this because you have a client whose matter has been dismissed, and you were litigating in federal court. So tell us about that experience and what you think it means going forward.
Sure. Well, first of all, let me dispel the notion that it was their trepidation about going up against me that led them to dismiss. I think that's probably an overstatement. But we start. Yes, well, we start by saying we have a great team at Debevoise on this case. Stephen Schlegel-Melch, Arian June, and Mark Flynn worked closely with me on it and were integral to the result, which was a great result. The case again that we represented Ed Hackard, who was an accountant at Markham. The case against him, just to start, was really a documentation-only case. It was an allegation that for a period during his audit years, he's been practicing for more than 30 years, never unblemished career, really an excellent technical accountant. But the claim was that he hadn't put together binders timely after completing audits, that he hadn't done memos, that he had supplemented the binders really sort of very technical documentation issues, and they claim these were violations of GAS or PCAOB principles, for that matter, or requirements, and therefore he violated 102E. Very, in our view, an unprecedented documentation-only case. Usually these cases are audit failures, and the case against the auditor is they, violated GAS or otherwise didn't identify frauds, et cetera. So to start with, the case was, we think, a stretch. So initially, we went through the Wells process. Ultimately, they decided to bring this as a 102E. And, soon after it was brought and Jarkozy was pending, we brought a constitutional challenge in district court. It was assigned to Judge Buchwald in the Southern District. And what was interesting in the initial charging document, they did not identify an ALJ. They never ever signed an ALJ. They basically suggested this was going to be a hearing held before the commission, which is something that they've done in many cases recently because of the other constitutional challenges that have been brought relating to administrative proceedings, separate and apart from Jarkozy. And so we brought the constitutional challenge on a number of grounds, including the Jarkozy issue, the Seventh Amendment issue, but also broader due process issues, because now you had a hearing before the commission, which has never happened before. The idea that Gary Gensler and the other commissioners, 2 of the 5 are not lawyers, are going to hold a hearing where they're going to spend 2 weeks hearing evidence and then issuing factual findings of fact and law, from my perspective, was kind of a joke. And there's no rules that govern that. In our first appearance in front of Judge Buchwald turned to the DOJ attorney and said, "Are there any rules that govern this sort of proceeding? It seems unprecedented." And the DOJ attorney said, "There's no such rules, Your Honor." And of course, Judge Buchwald was like, "Really?" And so initially the commission, the enforcement division, refused to even stay our case pending the constitutional challenge. But Judge Buchwald said, "Why won't you stay at least pending Jarkozy and hear what Jarkozy has to say?" And when she leaned on the enforcement division, finally they yielded and they agreed to stay the matter. So then Jarkozy gets decided. Obviously, Jarkozy, as you said, is focused, Tom, on the types of the penalty, that it's a penalty, and also the type of violation that was charged in Jarkozy, which is, something that as far as the court was found, under the Seventh Amendment, you have to have a jury trial to determine whether a penalty should be imposed. But there was language in Jarkozy which suggested, at least as you suggested, that a 102E penalty could be found to be required to have a jury to adjudicate. It was punitive. Arguably, 102E penalty is punitive. And so the language is a little bit ambiguous, but we think there was probably a good argument that the penalty was unconstitutional. So what we were thinking is quite possible that they'll just not seek a penalty. And one of the things we've been pressing before was for them to say, we're not. What was interesting in our case is the order that was issued, the original 102E order, did not seek a penalty. And yet they refused to say they would not ever seek a penalty in our case, because if they said that, they could have mooted the Jarkozy issue in our case, but they refused to do that. So, it was still live in our case, and we thought at least we'd have an argument on that. But the other thing that we argued in the amended complaint we filed after Jarkozy was that the bar, which is the key remedy that they're seeking in the 102E, is actually punitive as well. And there's some good case law, Johnson from DC Circuit, and some other case law out there, that bars can be punitive. They're not always punitive. They're sometimes remedial, but they can be punitive. And we were using that case law to argue that. I think maybe part of the issue here from their perspective is a concern that bars may be struck down on that basis. It also could be some of the due process arguments that, ultimately maybe they throw in the towel. We can't have an ALJ. It's very difficult for us to do that. We're not going to have the whole hearing. One possibility they could have thought about, and maybe someday they will come back to, is maybe having one commissioner be the hearing officer. That's a possibility too. It looks like there's that possibility, but they clearly didn't go that route. And then next thing we know, we communicated with the enforcement division, and they told us they were dismissed. We had the typical thing. They have a call, and it's 2 minutes. They're basically saying they're going to dismiss, and you basically say thank you for the information. You call your client, and they're just on cloud 9. So, from our perspective, this was a case shouldn't have been brought in the first place. It was a case that a documentation issue. Mr. Hackert is close to retirement. Frankly, this case was going to go on well past his retirement. There was no incentive, as we said to them, for them to seek a bar in this case, and yet they refused to yield on that. So ultimately, I think it was the right result for Mr. Hackert. But more broadly speaking, it's an interesting situation. I mean, we saw just a couple of weeks ago, they brought a new case against, I think it's OEM Boya was the accountant and the accounting firm in district court. And there, it's actually, if you read the allegations, it's basically like the accountant was co-conspirator in the actual accounting fraud. I mean, there's these suggestions of that in the complaint. And so one of the things they're seeking in that case is an equitable bar that would bar the accountant in that case from actually essentially being an auditor, outside auditor going forward. So what they're clearly trying to do in that case is use equitable bars and trying to have a court impose them. But that case is essentially a fraud case, right? And so I don't view that. I mean, but the kinds of cases that typically are 102E, our case was unusual and it was documentation, but usually it's a failure to apply accounting standards, to live, gas standards, PCOB standards. Right. It's not, a fraud case. And so are they going to do that going forward in other cases and seek in district court? I think that's aggressive, particularly since bringing a 10b5 case against an accountant for violations of accounting standards is an extremely aggressive position to try to argue in front of a jury that like this accountant committed fraud because their audit opinion said they complied with PCOB standards, and in fact they didn't. I mean, that's like, how is that, that seems like they've never brought a case like that. And that seems like a huge stretch. And so we'll see whether that's what they decide to do now. But clearly, I think, it's from my perspective, extremely important because it really does remove a specter. And why would anybody settle a 102E case at this point? Like, they don't have the ability to litigate it at this point. So, I think is what the future holds. We'll have to see.
Yeah. Well, those are two interesting possibilities. Hearings presided over by one commissioner, interesting, or trying to get an effective 102E bar in the form of an equitable injunction in federal court. Yeah, well, I guess we'll find out.
It raises the question of how fair that proceeding could be, because that commissioner voted based upon information not available to the defense. Right. That commissioner voted to bring the action in the first place.
Yeah, that was part of our constitutional challenge. Yeah. Like you've got the commission authorizing the case and then hearing the hearing. It's one thing if they're the sort of appellate body, passing on an expert fact finder, their recommendation. It's another thing to have them actually hear the hearing. So there was a lot of, I think, in the due process arguments, they were better than, courts have rejected a bunch of due process arguments on administrative proceedings, but I think our arguments in this case were actually much stronger. So, we didn't get there, but maybe someday somebody will.
Right.
Well, we had the instance where we filed motions and they were being decided by the Office of General Counsel, which also was involved in recommending that the commission should bring the action. And I remember talking to the staff attorney and saying, well, why don't we have our law firm's general counsel decide? So, well, that wouldn't be fair. That's the general counsel of one of the parties.
Well, what they typically do on that, Tom, is it's different parts of the general counsel, right? So you have one part of the general counsel that's advising the commission, and then you have the other part of general counsel that presumably is advising the enforcement division. I think that's typically how they would handle it back in the day, but I don't know what they're doing now. So
who knows?
Well, congratulations to you and the whole Devoice team, and to Mr. Hackard, your client. I guess we'll connect with you on the next constitutional challenge. But thank you for taking the time, Andrew. Tom, thank you as always. And for everybody else, please tune in for the next SEC Roundup and find out more information about ICANN at icanlaw.org. Thanks and goodbye.